Come, now here. Come. Come look here. Come. No. Off. No, it's not for doggies.
Dad! Vula la
Thank you. Welcome to the High Court Practice lecture. And unfortunately, I'm working from my desktop today, so you won't be able to see my face. It does not have a camera. Miss Sonia Labusnakne is our instructor for today. We've had challenges with regards to the recording. Our IT person is assisting us. I've noted most of the students are not able to open it. We tried to upload it on eLeader. It still does not open, but we are busy working on it. Once it's fixed, I'll be able to let you know. Sonia will be recording today. I'm hoping from her side, once she's done, she'll be able to. Then you'll be able to. Sonia, I'm handing over to you.
Thank you, Prudence. Can I just make sure that everybody hears me?
Can hear you, yes.
All right, thank you. Can I ask everybody to mute? And then if I can ask, if we're asking questions, can you please do it via chat? I am not always possible to see everybody. So if you can just chat for me, and then I'll go through as we go along and answer the question. All right. I've just said hello. Morning.
Yes, some of our chat function doesn't work. My two colleagues and I, we can't tap on the chat function and type a message or a question.
Neither can I.
Yeah, I think you can only do it on Zoom.
Yeah, mine is the same.
Good morning. Mine also doesn't work.
Sonia, maybe what they can do is that they can, if we can have a question and answer sessions and they can raise their hands and we attend. I'm not sure why they're not able to see the chat.
I'm very sorry. The sound is very bad. So I can hardly hear what you're saying. So if you can, if everybody has.
We also can't hear Prudence. Her mic is it's so soft.
I think it's because there's some people's mics that's on, that's why the sound is bad.
Okay, is this better?
Yes.
Hi, Sonia, can you hear me?
Yes. Okay. I think let's start.
I'm saying maybe we can have a question and answer session then after you've done presentation so that you can attend to the questions separately.
Yes,
Since
we
the
can do that as well.
see the chat session.
And it's not because I don't like to.
Yeah. If you can't do the chat, then I will stop you periodically and ask for questions, and then you can do it that way. So we don't have a lot of pressure at the back at the end. All right.
All right.
Okay. Thank you very much.
Thank you so much, Sonia. I'll be listening on the side. If there's something that you need, you can also just send me a message, or if you need me to attend to anything, I'll be able to assist during the day.
Thank you very much.
All right. Thank you. Bye.
Thank you. I want to just confirm, this is the first High Court session you have. Am I correct?
Yes.
Thank you very much. I just wanted to make sure of that. All right. with High Court, obviously everything is in turmoil. And unfortunately, I won't be able to tell exactly what's going on at the High Court because it keeps changing every 5 minutes. Every time I go there, something else has changed. So I wish I could give you guidelines, and we're going to try and do it. But we do live in interesting times, and so you need to expect things that change and things that are not going to be the same as you did it, even if you did just yesterday. So please keep that in. But we are going to just try to do general guidelines to assist you and how the process works. So please feel free to ask the questions, as I said, with regard to the chat, or later on we can ask questions. All right. We are going to split the sessions in two. I'm going to do the second day as well, which we are going to do in person. But today we are going to do actions, and then on the other one we'll do other day we'll do application. If it sounds familiar, it's because if you've done magistrates, a lot of the stuff will be the same. But we try and keep it from the perspective of the High Court, and I'm trying to show you the difference between the Magistrate Court and the High Court. They have streamlined the rules so that both our Magistrate Court and High Court basically have the same rules. So when you see something that sounds familiar, as I said, it might become from the magistrate. But it's always a good thing to hear things twice or however many times. Hopefully it sticks in their mind and you remember it. So please don't feel that you're wasting your time. It's always a good thing to hear things more than once. All right. Okay, I'm gonna just see if the videos are working because I've been struggling yesterday. They take some time to upload. All right. So the first thing is that what do you wear to High Court? I know, some people might not think that it's that important, but we need to know where we're going and what we're wearing. So let's just see if the video works. Apologies. My apologies. It keeps jumping back to the front. So I apologize. Let's just move on to the next one.
Hey, ma'am, my screen is blank. I'm not sure if it's just me and I cannot hear anything. Hello, ma'am, can you hear me?
Screen is working fine.
All right.
Mine is completely blank.
I can see
can't
everything and I can hear
All right.
everything.
Okay, so we'll skip the videos.
Log on again because it's completely blank on my side.
All right. Can you see anything now?
We can see everything clear.
Okay.
Maybe it's an internet issue for her.
Okay, but what do you mean see everything clear? Because I can only see the slide that says High Court practice.
Yeah. So it seems the video is a problem. All right. What we will do is we'll skip them, and then when we are in the class, then I can show them to them. All right. But today we'll just.
Thanks.
All right. Okay. So the point of the videos was basically to show you that there are issues with dress everywhere. So when you go to any court, and especially now the JP has issued an instruction that even if you appear in magistrate, you need to be dressed as if you are going to the high. So what we need is to see what we must dress like. Firstly, for attorneys, you wear your attorney's black attorney's gown, so nothing else. You don't have to do an advocate's gown or something. Then we have the white shirt or blouse closed at the neck. The white lace jabot. Now, if you don't know what that is, it's that frilly thing that the advocates wear, and it should be white, not that nice yellow color that you sometimes see. It should be really white. Dark pants or skirt, and then a black or dark closed shoes. For your clients, make sure that they neat. The other day I was in court and somebody was there in shorts and flip-flop. Really not appropriate. I know everybody doesn't have money for really smart clothes, but just neat, clean, and presentable. All right. So don't think as candidate attorneys you are never going to go to court. We are going to go. And even if you go for your day when you get admitted as an attorney, they also want you to wear black and white. So just to show, we're part of the profession. Interestingly enough, you put on the gown, immediately you have some respect from the public. So although it's hot and uncomfortable sometimes, please wear the correct ones. There are magistrates that refuse to see you if you don't appear in the correct dress. And obviously the high court, they're not going to be impressed either. All right, so this is just an introduction way and tell you, because I don't know if it's just me, I want to know what I must wear. So this is very easy, black and white. All right, so how do we address when you appear in court? Again, as I said, don't think you're never going to appear. We as attorneys are allowed to appear. And when you go there, you will note actually quite a lot of attorneys appear. And a lot of the judges used to be attorneys as well. So we actually very well represented in the High Court. So don't be afraid. All right. Firstly, you refer to them as the judges, my lord and my lady. The Constitutional Court and the Appeal Court has requested that you don't call them my lord and my lady. It's justice or the court, but in the High Court, it's still my lord and my lady. Then in the motioner, you wait until the next matter is called before you leave. So it's not what you say in the magistrate that you are. This is my role. May please be excused. But you just wait for the next matter to be called, and then you're right to leave, unless you are the second dealer, because then you have to wait till the court adjourns. This is just so that if the advocate needs something and you can assist him, there is somebody to assist him. All right. Then very, very importantly, please do not see the judge alone if the matter is opposed. You always take your opponent with, wait for them or arrange with them, and then you go to court together. At the moment, I know judges aren't really seeing anybody in chambers because of the restriction. So you are introduce yourself in court. Very important. But I know also with regard to magistrates court, there's a lot of security involved, and they not always allow people to. But then just tell them you tried, and you apologize, and then you introduce yourself. All right. Now, advocates, I don't know if you're aware, but maybe you've been realized it by now. We are not the most admired profession. People don't necessarily like us. The only people that like us, and they must like us, is the advocates, because we give them work. So usually they suck up and they take us for lunch and they give us coffee and tea, so which is quite nice. But don't be intimidated, man. A lot of them, well, actually most of them, has gone through the same training as you guys. So if they are on your same level, practicing wise, they know nothing more than you do. So don't be intimidated. And if you're not happy with what they do, tell them. And also with regard to even SCs, I know we feel really intimidated and we said, oh my goodness, the essay, you see this and that. If you don't agree, tell them. Because at the end of the day, you are still responsible to the client. So make sure that both of you are happy and that the advocate is following the instructions. And if they don't agree, then obviously I will tell you. And if the two can't find a middle ground, then you need to find another advocate. Okay, so very important. When you give your documents, your brief to the advocate, never give originals. I don't know if you've ever been to an advocate's offices, chambers. There's no filing system. They throw everything once they're done there in a corner, and there's just nothing to find anything easy after that. So never give them the original. Make sure you have copies of what you've given to them, and then obviously give them a summary of what's happening in the matter, because they're coming in cold. They're not having to have the background you have. They haven't spoken to the client. So just give them a little bit of some summary so that they can see where it's going. Nothing wrong with confirming the fees beforehand. Because if you look at the code of conduct, you are liable for the fees. You and the firm and everybody that's ever worked at the firm is liable for the advocate fees. So make sure you find out what the fees are, get that from your client, leave it in a trust account so that you can pay it once the advocate is rendered his account. All right. Now, advocates are also not the fastest people in the world when you give them something to draft. So you need to give them time limits. Make sure that they know that this must be done with by this time, and push them if they don't. So, as I said, the responsibility stays with you, and you need to make sure that everything is done is done. Okay. So what we're looking at is the Superior Court Act 10 of 2013. This was promulgated on the 23rd of August 2013. And this is the act that's now implemented. Now, I understand you thinking, but Sonia, this act is so old. Why would anybody think that it's not? But unfortunately, there are some practitioners that do it in terms of the old act. So make sure you got the new act, that you got the new references and the rules. All right. So who can tell me what does the Constitution 17th Amendment Act, what did that stipulate? You can raise a hand or you can send me a message. Oh, silence. Okay. Nianda. Am I right?
Change the name of the High Court, Superior Court to High Court?
Yeah, no, that's more the Superior Act, Court Act. This is the Constitution 17th Amendment Act. Come, be brave.
Mine is up that the Chief Justice is the head of the judiciary.
Sorry, just say again. Are you scared now?
Struggling with the mic, sorry.
Okay, no problem. We've all had our technical issues today. Nobody brave. Ah, my word. And you all want to be attorneys. You can't be attorneys if you don't speak. Luckily you're far away from me, so I can't do anything to you. All right. So the Constitution 17th Amendment made the Constitutional Court the apex court, so that all appeals can go to it. It's the final court. It's got very strict requirements, so you can't just appeal to, and we'll get to that a little bit later. But now it's not the appeal court that's the apex court anymore. It's the Constitutional Court. All right. So with any matter, doesn't matter what type of matter the clients come to you, because when the client initially comes to you, not sure what type of matter in it, but all of them, you have to do FICA. I know we don't like FICA. When I go to the bank, I want to jump through the roof because of it. But information is power. So the more you know about your client, the better you can help them, assist. And when they don't pay you, you know where to sue them. So what we need from a natural person is what we would normally have, when the banks are doing. So it's your ID and proof of address. With close corporations, companies and partnerships and trusts, you need to have authorization. So they need to give you a resolution or some other way of authorization that they are entitled to appear or act in for this company. You also need the registration papers. For the trust, you need your letter of authority as well. So make sure you have all these things in place. You don't want to go to court and then suddenly, somebody says, but this guy's not allowed to appear on behalf of this company. I mean, so make sure you have that. And also, when you send your account, and the company comes back and says, "But who you?" We don't know. And you say, "No, John instructed me." No, but John's the janitor. He's not allowed to instruct you. So be careful about that, and make sure that you've got all the papers that you need. I always say, as attorneys, we love paper. We need to, find something to ruin the Amazon. We don't, they always say we'll become paperless, but I don't ever foresee that, not in our lifetime. So unfortunately, we do love our paper. All right. And then, once you've consulted with the client and you find out what the problem is, and you've decided, all right, the High Court is the way to go, the requirements that you would have for a normal way to start an action applies. So you need to make sure, all right, do we need to do a letter of demand? And you have exactly the same requirements as you would have in the magistrate's court. So who can tell me for which matters, which type of matters, do you have to first send a letter of demand before you can issue something?
Having a date.
Sorry.
Sorry.
Repeat that question, please.
Okay, so for which matters, type of matters, do you have to do a letter of demand before you can issue summons?
Section 129 of the National Credit Act, credit agreements, dates.
Yeah.
Yes, okay. So Section 129 of your National Credit Act. Anybody else got another example?
It's usually
suing an organ of state.
Organ of state, correct. So for those two, you have to sign first send a letter of demand. There would be others as well, but those two are the most well known. So we're going to have a look in detail on our legal proceedings against the state, because there are various requirements. And unfortunately, most of the time of the litigation in South Africa is against the state these days. So we need to make sure that we know what the requirements are, because otherwise, the clients will sue us for negligence, and that we're trying to avoid at all costs. All right. The first the act we're looking at is legal proceedings against certain organs of State Act. It's one of those long names. And this act commenced on the 28th of November 2002. Okay, so it doesn't apply if your debt prescribed before that date, or legal proceedings have already been instituted. So we're talking 20 years ago, so I'm assuming these two, don't really matter anymore, because it would have prescribed long ago. And if you instituted legal proceedings, they hopefully by now would be finished. Okay, so what is an organ of state? Organ of state is a national or provincial department, a municipality, an institution authorized by South African Constitution. Who can give me an example of that? What would be an institution authorized by the Constitution?
The public protector and other Chapter 9 institutions.
That's correct. So the public protector, or the Independent Electoral Commission, those kinds of things. All right. And then institution authorized by a provincial constitution. For instance, did you know that in the Western Cape we have a police umbud, which is only for the Western Cape. So that would be an institution authorized by a provincial constitution. Yeah, South African Maritime Safety Authority, SANRAL, South Africa Roads National Agency Limited, and any person whose debt the state is liable. So you can see it's very wide. What is the debt? So the debt is very widely defined. It is either intellectual, contractual, or any other liability. Your Chapter 3 of the Prescription Act is applicable. So that would be the normal 3 years from when you become aware of the debt. And so the normal rules of prescription apply to debts of the state. So it's unfortunately only the SARS that have 30 years to collect debts, but all the other debts is only 3 years. All right. First thing that must be done in terms of Section 3 is that a notice must be given. And you cannot institute proceedings against the state if you haven't done this notice. And what it requires is that the notice must be served on the applicable organ of state within 6 months of the debt becoming due, must set out the facts giving rise to the debt, and you must set out the particulars of debt known to the creditor. Now, we know that sometimes, especially if people are in an accident and they're in a coma, that might be that they don't know the facts giving rise to the debt because they've been in a coma for a long time. So then obviously that time moves along. All right. So you can say, right, I was in a coma, I didn't know what was going on, and therefore your 6 months is extended. But you need to be aware of the 6 months, and you must do this letter as soon as possible. And sometimes the clients come to you quite late because they didn't know they had a claim. So we need to take that into consideration, especially when you consult and get your details as soon as possible and write the letter. So the debt is due only when the creditor knows the identity of the organ of state and the facts giving rise to the debt. The creditor is deemed to have knowledge as soon as he, she, or it could have required it by exercising reasonable care, unless the organ of willfully prevented him or her from knowing. Especially with medical malpractice matters, the hospitals would sometimes keep back information and not give everything. And then again, as I said, especially when you were in a coma and you can't remember, you're now relying on the records of the hospital to tell you what's happened. And if they don't want to give it to you, you sometimes have to bring an application to force them to bring it to you. Luckily, condonation is available. So as long as the debt has not been extinguished by prescription, there's good cause for the failure of the creditor, and the organ of state is not unreasonably prejudiced by the failure, you can bring condonation. So if the client only comes to you 2 or 3, 2 years, because 3 years we've got a problem. 2 years after the incident happened and debt is due, then you need to, obviously describe why he's so late, and especially if you've got a client doesn't know the law, is indigent, and he didn't know what the facts are, and he only came to about it knowing it, recently, you should be able to get condonation. The question then arises, when you ask for condonation, do you ask for it when you write the letter, or do you only do it when the state takes a point and say you didn't write the letter in time? And what Johannesburg has said is that your condemnation is only necessary if the state does not take the point. So if they raise it and say what you didn't send your notice, then you can bring your application condemnation. And it's important to note the magistrates court also have jurisdiction to listen to an application for condemnation. So you don't have to do this in a high court. All right. How you must deliberate. The notice is set out in section 4. It can be delivered by hand, certified mail, email, or fax, and it must be delivered to the various functionaries. Now, that's very important that you're sending it to the right people, because otherwise that would also be raised as a problem, and you might have to ask for condemnation even though you sent your letter in time. So section 4 says, especially if you're doing a national or provincial department, then you look at the schedule 1, 2, or 3 to the Public Services Act. Then that will tell you who the officer is to whom you must address this notice. In the case of the police department, it must, however, be sent to the National Commissioner and the Provincial Commissioner of the province where the cause of action arose. So be careful about that. Once you've sent your notice, you have to wait 60 days after the notice has been served. You're not allowed to issue summons before that. If you've got a problem with prescription, obviously you need to maybe ask the court for permission to send the summons earlier, or otherwise just bring an application later on to say, after asking for condemnation because I sent it, I'm suing before the 60 days are up, but it was because of prescription. All right. If the organ of state repudiates in writing the liability for debt, then you can also sue, but the chances of that happening is virtually null because they don't really do that. All right. Then it must be issued, your summons must be issued in the court in whose area of jurisdiction the cause of action arose, unless they consent to, which again they won't do. So this is a new addition to the Act. So I haven't seen any court cases about it yet, but I can foresee that this is a problem because not everybody will be able to sue in the court where the cause of action arose, especially if more than one defendant and they are in different areas of the country. Then you might have a problem. So we'll see how this develops. I don't think that this is correct for them to do. You have, in terms of the High Court and the magistrate, more options as to where to issue the summons, and the court will have jurisdiction. So I don't think it's constitutional to limit it to just the where the cause of action arose. So we'll keep an eye out for that, but just please keep in mind to make sure that you issue your summons where the cause of action arose. We'll come back a little bit late to discuss where the cause of action arose. You will see there's quite a lot of requirements, so it can be quite tricky as well. All right. Then you need to look at the state liability. Can you now see we are on our third act already? So you need to make sure that you comply with all these acts. And this act says that if you issue summons against the Minister of State security. Then you must also serve it on the Director General, State Security Agency, at the head office of the party as well. For the Minister Police, we again need to serve your summons on the National Commissioner as well as the Provincial Commissioner as set out in the Act. And then for the Minister of the Correctional Services, you also need to serve it on the Commissioner of Correctional Services, and that's the national, and the Provincial Commissioner of Correctional Services. So these are additional requirements on who you must serve it, added to the list as set out in the Public Administration Act on who you must serve. So as I say, be aware. Very important in terms of State Liability Act, it also requires you to, after you served it on the correct person, you also need to serve it on the state attorney that operate within the area of the jurisdiction of the court. So always remember to always serve it on them as well, because remember, at the end of the day, they will represent the state, and so they normally would like to know before your DAS is up that there is an action, because they don't always get instructions from the State Department. Okay, well, while we're talking about DAs, and you will remember with DAs, that's the amount of days you have to defend the action. For the state, they've made it longer. So normally for a summons, they have 20 days to defend the matter. For an application, they have 15 days to defend a notice of motion. So always remember when you draft your documents that you change the days if you're issuing summons against the state. All right, so let's start seeing what type of matters you can bring to the High Court. We've now decided, after consultation with a client, we're going to the High Court. What can we take to the High Court? So contracts, delictual actions, you have any other cause like maintenance or enrichment. And what you need to allege is that it's a legal fact giving rise to an obligation which results in a liability. I can't just sue somebody because I don't like them or I don't like the color of their shirt. I need to be able to see you owe me something. And it doesn't necessarily have to be money. It can be a thing or something they have to do. But you can't just go to court for the fun of it. I don't know who would want to, but maybe people are bored. So very important. Okay, you must have a legal fact that gives rise to an obligation which results in a liability. And then, as we said, your cause of action must be complete. So you can't sue halfway through a contract which still has time for it to be completed, unless you can show that it should have been done by a certain date. And then we must complete our action by doing our letter of demand, as we discussed just now. The second thing that you need to look at when you're issuing summons is locus standi. Thus, the person that is issuing the summons the right to issue the summons, and also the person is suing. Can that person be sued, and is he the correct person that is being sued? So there's two questions you have to ask. Firstly, there must be a direct and substantial interest in the right, which is the subject matter of the litigation. in the Constitution, they did create the opportunity for group actions. So you might find people that do not have a direct interest issuing summons. That would normally be somebody like an NGO who's representing a group of people, let's say, for instance, children, and they are saying whatever is happening is not good for the children, and we want to bring an action or application on behalf of the children to remedy the problem. And for that, you are allowed to in terms of the Constitution. But most of the time, you must make sure that you have a substantial right. And then also that includes everybody you need to add as a defender. You need to include everybody that has going to be or have a right in this litigation. What we're going through these things is very important, because you must remember, you must do most of your work before you issue summons. I know attorneys, they tell the client, no, let's quickly do a summons. They'll get a fright, and then they'll come to the party and they pay, or they'll do whatever you want them to do. It doesn't work like that, because people will defend it, and if your summons is not correct, they either can be dismissed, or with an exception and an or regular stay, which we'll come to later. And the problem is you lose the matter, and now the client had to pay you to issue the summons. He hasn't even won his matter. He's not getting his money from the defendant, and now he has to pay the defendant's legal fees. So please don't think you can just quickly bang out a summons and run with it, and the other party will get scared. It doesn't. It's not happening. You need to make sure that you do your investigations, you do your research, whatever you want to do before you issue summons. You do it before the time. It's no use doing it when you're getting to trial. Then we're very late. And then if you have to change things and amend things, cost implication. And while I'm talking today, you will note that I bring up cost quite a lot. And it's not because I'm, want to get a lot of money. I do, but, but that's not the reason. The reason is that cost has a huge implication on how we litigate. You can use it as a leverage, to get the other party to settle. But if your client has to pay the cost, and he has to pay you, and he's sued for money, and he's not even getting paid the money that he's owed, he's not going to be happy. And he's not going to blame you. Well, he is going to blame you. That's the point. Unfortunately, remember, if you win a case, it's not because you're a good lawyer. It's because the client had a good case. If you lose the case, it's your fault. So, as I say, we never win. So please keep that in mind. A big part of what we're doing is to cover ourselves against ourselves and our clients. So beware of that. Unfortunately, this is a stressful profession. We're dealing with other parties' money and other parties' problems. They come to you, they consult, and now the problem is yours. It's not their problem anymore. So you need to sort it out. So if you don't, obviously you're a bad lawyer. So we're going through all these requirements so that you can do your investigations beforehand, and you don't come to a surprise once we trial 2-3 years down the line. All right. Okay. Now, obviously, as in law, there are always exceptions with regard to locus standi. Firstly, you need to be 18 years and older to be able to issue summons. But you are allowed to do it if you are represented by a guardian. That could be by the parents, or if the parents aren't available, or you are actually suing the parents, a curator ad litem must be appointed. This matter, Legal Aid Board what happened is that the children actually sued their parents. The parents were divorced and they lived quite close to each other. So it was quite a good arrangement for the children. They could go visit the one whenever they want, and they could visit the other one. So they had good relationship. The mother then met somebody that lived in Dubai. She wanted to get married to him and then move everybody, her and the children, to Dubai. And the children wasn't very happy because they felt that, this is taking away their right to visit the father. So they then brought an application to court to say, look, we're not happy with this decision. And the court had a long discussion and going to and fro. And at the end of the day, said, well, we need a curator at litem for the children because obviously they can't use the parents as guardians. And then the court said, okay, well, we need somebody like this. The legal aid board was representing the children, and they said, but we can't be the curator at litem because we're representing the children. So they took the matter on appeal, and in the meantime, everything was sorted out, and the children didn't want to go ahead with the application, but the legal aid said, no, we need clarity on this. So the appeal court said, right, you don't really have clients, so there's not going to be a result here, but we'll entertain this application. And they said that as the curator at litem, or as the attorneys, they're very well suited to be the curator ad litem as well. So the legal aid board can appear for them and be appointed as the curator ad litem. So always remember that if you have children coming to you for advice, they are entitled to appear. If the parents cannot be the guardians, you can be appointed as the curator ad litem, or you could get the legal aid board to assist as well, because obviously children are not going to have money. So the legal aid is very well positioned to assist them. If you are under curatorship, and there are two, there's a curator bonus, which looks after the person's property and affairs and doing. So they do the day-to-day running. And then the curator ad litem, he represents the person, whether it's major or minor in civil litigation. A lot of times people have, they might have been in an accident, and a curator ad litem is then appointed to assist them with litigation because they're not allowed, they cannot assist themselves, they don't have the capacity. Then you would sue the curator ad litem, or the curator ad litem would sue on their behalf in their capacity as curator. Mentally disordered person also don't have the capacity to sue or be sued. Again, you need to the curator who represents them. Always, this for me is such an interesting word. The Afrikaans is very nice. It's verkwister. You understand what they mean. Well, for me, they spend the money, but the English is interdict prodigal. And somebody explained to me it comes from the prodigal son in the Bible. That's just an interesting aside. But if you have been declared an interdict prodigal, you also don't have the right to or be sued. You have limited legal capacity because you're not allowed to deal with your own money. Unrehabilitated insolvent also has diminished locus standi. A married person, if you're married in community of property, you must get written consent from the other spouse before you can issue summons. Except obviously if you sue each other for divorce, if it's out of your profession. So as an attorney, if you want to sue a client because they owe you money, but you're married in community of property, you don't need the consent from your spouse. You can issue your summons against the client for the monies owed. Then also for damages for delict, if you want to sue somebody because they defamed you, it's your personal, that you can sue, and you don't have to get permission from your spouse. Other natural person cannot be sued or sued is judges of the High Court. You need to get consent from the court to issue summons. A number of years ago, there was a professor from America, I think. He wanted to sue Judge Slope for defamation, and he applied, and one of the judges granted the permission for him to sue. So I'm not sure if the Judge Slope is very happy with that judge, and that might be the rumors that are going around about the hitman. No, let's not go there. But in any event, so to sue a judge, you need to get permission. Members and officers of Parliament can only be sued in Cape Town. You can, they can sue anywhere else, but if you sue a member of Parliament, you must do it in Cape Town, because obviously what they do is they split their time between Cape Town and the rest of the country, or where their constituency is, and so it's difficult then to establish jurisdiction. Diplomats, we have immune to civil and criminal proceedings. People have always asked me why, and it's something that resulted from the Second World War. When they would just grab the diplomats of the opposing country and jail them for no reason because of the fights. So that was then to protect those people from being sued or being jailed for no reason. If you're a fugitive from justice, you cannot sue, but you can be sued. But I foresee some practical problems, because I don't know how you're going to find them. If he's a fugitive, then it implies that you can't find him. But in any event, if you do find him, you can sue them. Whenever I see this next one, alien enemies, I see ET. So I'm always amused by it. But let's say, for instance, Namibia decides to invade South Africa for whatever reason, then all Namibians that live in the country cannot sue, but you can sue the Namibian if you've got a reason. Okay, so very important. Jurisdiction. Okay, I'm going to bang on about jurisdiction for quite some time, and you're going to ask me, Sonia, why? Why are we wasting so much time on jurisdiction? It's because this is where you can lose a matter without even going to court or to trial. So you must be very, very important that you are in the correct court. All right? So jurisdiction is the legal competence of a court to hear a specific matter and to grant an order in that matter. So the court must be able to, give a direction which is in his power and which can be executed. Lately, there have been quite a number of court cases that deals with the fact that if the magistrate's court has jurisdiction, then you cannot sue in the High Court. For instance, especially with National Credit Act, the National Credit Act specifically says that the magistrate's court has jurisdiction with regard to all NCA matters. And as normal, with it is, they rather go to the High Court because they think the magistrate court takes too long, or they don't know what they're doing. And so the High Courts gets inundated with a lot of actions that wants money with regard in terms of the NCA. And most of the divisions, the various divisions, has decided now you're not allowed to come to the High Court. If you can go to the magistrate court, you must go to the magistrate's court. They don't want to entertain it. So be aware of that. And then also, lately, there's a case about the sectional title homeowners association. There's an UMBAT that looks after them, and the court has said, in these types of matter, you must go to the UMBAT. You can't come to court first, especially when you deal with homeowners associations and sectional title, where they levied fines for minor things, not correct building in terms of the rules, or using a garage for something other than being a garage. And in the bigger scheme of things, those are relatively small issues, and the court felt that should be rather sorted out by the Ombudsman. Also, with regard to PI, be aware that in terms of the PI Act, it also says that the magistrate's court has jurisdiction. I've not seen a case yet where the High Court has refused to look at a PI application, but I do think it's going to come. So be careful. I don't know why you would want to go to a High Court, even if your amount is more than the jurisdiction of the magistrate's court, because usually your lease agreements say you can go to the magistrate's court. So I would rather you go there than the High Court, because you do run the risk that the High Court's going to sometimes say, we're not going to hear this matter. So keep that in mind. The High Court does have a inherent jurisdiction, which means that they can decide if they want to hear this matter. It gives them a larger discretion than the magistrate's court, because the magistrate's court is a creature of statute, and they can only do what the Act tells them to do. So in a High Court, look at Section 27. 27 does give you the right to remove the matter from one division to another. And you can do this, you can bring this application even if the court does not have the jurisdiction. It's one of the things that the court will take into consideration if the court has jurisdiction. So say, for instance, you issued your summons in the incorrect High Court. The people live in Johannesburg, but you issued summons in the Western Cape, and then you realize, and they raise maybe an exception against or a special plea, and now you have to look and say, okay, what am I going to do? In terms of this section, you can bring an application to transfer the matter from the Western Cape to Gauteng. You must, however, remember that court will probably give costs against you if they grant it. They have a discretion. They might say, no, you know what? Withdraw this matter in this court and issue summons in Gauteng. Again, cost implications. And not only that, if you are close to prescription, then you must remember, if the summons gets withdrawn, it's not an interruption of the prescription. That's if the prescription is run from the start. So if you're close to your date of prescription, your matter might have prescribed by the time that you withdraw your summons. And then you have a problem, because you can't issue summons if the matter is prescribed. So that's why I keep on saying, be careful about jurisdiction, make sure you're in the right jurisdiction. There is an option for you to transfer, but it's not a guarantee. Court has the discretion to either allow it or not. And so you might lose the case, and then you won't be able to issue summons. All right. In Section 50, of the Magistrates Court Act. It gives the permission that the matter can be transferred from the Magistrates Court to the High Court, but that is only available for the defendant. You would use it, for instance, the plaintiff would issue summons in the magistrates, and the amount is within the jurisdiction of the Magistrates Court. But now the defendant raises a counterclaim, and the counterclaim is outside of the jurisdiction Magistrates Court. The amount's higher, and then the defendant can apply and say, all right, can we transfer to the High Court because my matter is outside of the jurisdiction of the Match Court, and obviously the plaintiff is going to raise that as a defense, and so the matter can be drawn. But that's only for the defendant. Okay, so let's just have a look at the various divisions of the High Court. So each province has a seat and has a High Court. So we've got 9 High Courts. But we also have local seats. And if you look at the Eastern Cape, it does have 3 local divisions. Durban is another one for KwaZulu-Natal, Thohoyandou for Limpopo, and then Johannesburg is the Gauteng local division. So make sure when you issue summons that you again are in the correct division. You can go to the main seat if there is a local division, because the main seat would have jurisdiction over the whole of the province. But if it's easy, you do have the opportunity to go to the local division if that will assist with regard to costs. In the Western Cape, the heading is in the High Court of South Africa, Western Cape Division, Cape Town. All pleadings must be in English. All right, no other language. You have to translate if you have other languages. If you don't have the correct heading, the registrar won't issue the summons or the application. And as you know, they are very friendly and very helpful. Not, but so if you arrive at court and your heading is not right, they will send you back. And I've tried to say, well, okay, can I amend it and I'll initial next to it? They don't want to do that. So not interested. So make sure that the heading is correct. So what jurisdiction does the High Court have? So it has jurisdiction over all persons residing or being in the area. All matters it may take cognizance of, especially with children's matter. So even if the child don't live there in this area, if the child's moving through the area, you're allowed to take the matter to the court. Very important to note that domicilium is not enough to establish jurisdiction. All right, so recently there's been a case where the sheriff served the matter on the grass because that was the domicilium address. It's just literally said in the return, served on grass. And the court was not very happy. So we'll come back to that later on as well with regard to one of execution of immovable property, and they declared the whole sale invalid because of the summons that was not served correctly. So be careful about that. Even though you got a return from the sheriff and you're very happy because it's now been served, and now you just go ahead and you take your judgment. Later on, they can come and bring an application to rescind, and one of the reasons could be because the summons was just served on the domicilium, and that could obviously again have a cost implication. And in case of this sale and execution, the whole sale and transfer was declared invalid. So you think fine now when you're taking judgment and it's granted, but down the line, it can come back to bite you. So be careful with the domicilium addresses. Now, we've spoken about all causes arising within the area. Note specifically with your NCA matters, the Supreme Court of Appeal has said that your notice in terms of Section 129 is part of your course of action. So if you delivered your letter outside of the jurisdiction of the court, that court does not have jurisdiction if your cause of jurisdiction is the whole cause of action. Obviously, if your person lives in the jurisdiction of the court, then you're right, you're fine. But for instance, if you send your letter of demand to Uppington, and it's a property falling in the Western Cape, but you are making the allegation that your whole cause of action arose in the Western Cape, it's not going to be an assist you, because your Section 129, which is necessary to complete your cause of action, happened outside of the jurisdiction of the court. So please keep that in mind. You can attach the property to confirm jurisdiction, except if the defendant is resident in South Africa, because obviously then you can use the normal reasons for jurisdiction. And you can't attach a property to find jurisdiction. You could do that, but not anymore. So the action procedure can be divided into the pleading stage, preparation for trial, and trial itself. You must remember that the whole litigation process is actually strategic management. You don't really want to get to trial because you can't control outcome of the trial. Somebody else makes that decision. So if you can settle the matter anywhere in this process, both parties win. And remember, in a good settlement, both parties are unhappy. So if they're unhappy, you've got a good settlement. So I'm going to try and as we go along with regard to what happens, the different stages, show to you what the strategic planning can be and how you can use certain things to your advantage to settle the matter. Remember what I said about a cost. It's a great leverage. So I always say, don't think the goal is not to get into court and into trial. In my opinion, you've lost if you get there because you're losing control. Because as I said, somebody else makes a decision. While you are proceeding and you have control and you can decide, all right, this is best for the client and for the matter. Because remember, if you have certainty, even though you don't get your full amount, then you know who must pay what by when. And that makes life much easier. You know, but the client might not get exactly what he wants, but he knows he's going to get paid at a certain time. And that can be made an order of court. And if it's not done, he gets execution. If he goes to trial, the opportunity is there that he might get nothing. And then he has to pay the cost of the defendants as well. So we need to always keep in mind that we must try and settle. If the client doesn't want to, by all means, you go to trial, but we get your money first. And that's a great leveler and leverage for a client to settle. Because you don't think he's going to settle if he doesn't have to pay you. Pro bono clients, which don't pay, are the worst because they don't want to settle, because it's not touching them in a pocket. Once you send him an account and he has to pay before he proceed, it touches the pocket. And then they start thinking, oh, okay, this matter for principle is not so important anymore. So always Don't leave it till after you won the trial and then give your account. You're not going to get paid, even if you win, because remember, it's not yours. It's not because you were a good lawyer. It's because you had a good case. So you had nothing to do. So please, as I said, I know it sounds terrible, but it's it's to your benefit and also to the benefit of your client to give them regular accounts. They must pay before you proceed. It's a type of feedback that they get. They can see what you've done. If they're not happy, they can tell you, and the matter could be sorted out before we get to trial because they're realizing it's going to cost them a lot of money. Okay. Do we have any questions at this stage?
No, ma'am.
Nothing. All right. So,
Ma'am, just one quick question. I
yes.
just wanted to hear from you. Just regard to these slides.
Yes, you will be able to get it.
Thank you so much.
Pleasure. All right. Shall we break for tea? Quarter of an hour?
Ma'am, do we have to email you for the slides?
Yes, I will give you my email address at the end.
Okay, perfect. Thanks.
All right. So we'll take a break till 1:15.
Okay.
Okay, thank you. Okay, hope we're back. Can you hear me?
Yes.
We hear.
All right, thank you. I've taken out my headphones because I'm getting terrible feedback, but I'm still getting feedback. So hopefully this will work a bit better. If you can't hear me, just let me know. So let's proceed. Yes, Marnus? Saw a hand raised. Okay. All right. So let's proceed. So the pleadings that you get in your litigation process, it's very important to realize when you are dealing with a pleading, because as you will see, if we want to attack a pleading, we have to make sure it's a pleading. You can only do certain things with pleadings. And you will see as we go along why it's important then to differentiate between a pleading and just a piece of paper, if we can call it that. Even though it has a case number on it, it doesn't necessarily mean that it is a pleading. So a summons, a plea, counterclaim, plaintiff's reply, plaintiff's plea to defendant's counterclaim, request for further particulars, and the answers to further particulars. Those are seen as pleadings, and we would have certain remedies to attack them if something is wrong with them. I put exception here with question marks because it's not certain if an exception is a pleading. There's a court case in the Eastern Cape that has confirmed that it is, and that has never been challenged. So we'll work on the assumption that an exception is also a pleading. Obviously, let's start. An action starts with a summons. And I've just set out here the difference between the High Court and the Magistrates Court. In the High Court, you only get two types of summonses. The first one is the ordinary one, which is then split between a simple and a compound. Compound is the same as combined. It's just another word. So a combined summons is also known as a combined summons is also known as a compound summons. The second type of summons that we get is our provisional sentence. I do not go into that. It is a favorite question in the exams to ask about provisional sentences. So please don't think it's important because I don't deal with it. Make sure you know the time frames. Make sure you know the process. Because as I said, it's quite a frequent question in the exams. In the Magistrates Court, we get four different summonses. Your ordinary, which is then split up between your simple, compound, or combined, and your divorce summons. Please make sure that you understand that your divorce summons is slightly different from your combined summons. We have our rent interdict, provisional sentence, and interpleader, which is then also split between the stakeholder and the sheriff. So those are your big differences with regard to summonses between the two courts. When do you use a simple summons and when do you use the combined summons? The simple summons is used for a debt or a liquidated claim. You use Form 9, and then Rule 17.2 indicates that you shall use a simple summons when it is a debt or a liquidated demand. In the Magistrates Court, you may. So in High Court, if you're suing even on a mortgage bond, which is a debt, you use a simple summons. So even though you have to make a lot of allegations and there's attachments to it, you would use a simple summons. Everything else, you would use your combined summons, and that is Form 10. So those forms obviously at the back of the rules, and it's important that you make sure that you comply with it. Make sure that your template that you're using, because I'm sure all of you are using templates, comply with the rules. Otherwise, there will be consequences, and we'll get to them a little bit later on. So what is a simple sum? What is a cause of action in a simple summons? What is a debt? So payment of a debt, obviously, delivery, transfer, eviction, cancellation of a contract. So for any of these causes of action, you can use a simple summons. You cannot use a simple summons for a divorce or a declaratory order. And also remember that you cannot get a declaratory order in the magistrate's court. So if you need one, even though your amount might be small and the magistrate's court would have, you normally have jurisdiction with regard to that amount. If you're asking for a declarator, you need to go to the High Court. I want you to have a look on page 49 of your notes. There is a self-assessment question with regard to summons, and you will find the summons on page 137. So you don't have to draft the formal summons for me, because that usually we have either in a template or a form. I want you to just have a look at the question A, and draft for me the necessary averments. If you could upload it for me on the chat, then I can have a quick look at it while we are in the lecture and give you feedback on it. So if we can use 10 minutes now for you to draft and answer that question.
Sorry, ma'am, we did not receive the course packs yet, and we're not able to type in the chat.
I do not think she heard you.
Yeah, I also don't have those course packs. Are we supposed to message Prudence for a follow-up on that?
Prudence doesn't even respond
to contact.
I don't know about you guys, but I don't have access to eLeader.
Oh no, that's simple.
So I've emailed Prudence, and she responded today to say that she is lodged with eLeader to add me, obviously, onto the platform. So maybe you guys should try that.
On the platform.
But eLeader doesn't have the notes either. eLeader has other notes, not the course pack.
Oh, okay.
eLeader does have notes.
It does have notes, yes.
Sorry, if you just go onto the course, online courses 2020, and then you go to civil procedure, and then you scroll down to trading guides, there should be a High Court pack
I'm
there.
actually starting to download some of the stuff, the criminal stuff. I'm not even, it's not even saving.
I think it just takes a while because they're quite big. But if you just like fine, yeah.
Yeah, no, I don't know what's going on here. And I've emailed get a response.
Sorry. I was under the impression you all had access to the notes. They told me it was on the LSSA eLeader platform. If it's not there and we're struggling with it, I don't want us to waste time on it. It's good for you to do this. I'm just drawing your attention to it then. Please do it in your own time. You will get the answers to this. Either you have it already or you will get it. But it's good for you to draft. Remember, in the exams, you're going to be asked to draft. It's not just going to be short questions. And the only way to learn how to draft is by actually writing. So please do it in your own time. Please, when you prepare for the exams, do those self-assessment questions and physically write them out. And as I said, you will get the answers, and then you can check and see if you're correct. All right, but let's carry on then. I don't want us to waste time if you can't do it. All right, summons. Okay, so what you must allege in your summons is called a causa. So you must have all the factual allegations necessary to found a plaintiff's claim. Now, I know it's difficult when you're just starting out to know what to allege. If you have access to AMBLR's precedent of pleadings, please use that. I'm not getting paid to tell you this, but I find it to be a most useful book. If you speak to your principal, see if you can obtain that book. Otherwise, it is on the electronic platform of JUTA. So you will be able to access it that way if you have access to JUTA. It is not the same as an affidavit. Remember, in the affidavit, this is the evidence that's in front of court. So you need to tell the story. In the summons, you make just factual allegations. So you're not telling the story in a way. You need to look at what you must prove and make those allegations. The easiest way to do that is to look at what you want. You sort of start at the end. So if your client tells you X, Y, Z, this, that, and the other, then the first question, don't make it the first question because normally they wouldn't know what to answer you. But during your consultation, make sure you ask them, what do you want? Because usually they don't have any idea. It's very important to realize where you're going. You know, with a GPS, if you don't tell it where you want to go, it's not going to be able to take you there. So you need to find out where you're going. Are we claiming money? Are we claiming a thing? Are we claiming some sort of, say, for instance, if you need to ask for them to do something, just find out what you want to do, and then work your way back. Because if you know where you're going, it's easier to then see, all right, what must I allege and prove to be able to get this? If you don't make the allegation in your summons, it cannot be considered during trial. So, in all these movies which we see, in the court cases, then near the end of the court, everything's going bad and they're going to lose. And then 5 minutes before the end of the movie, they take out this piece of paper and that proves everything and it destroys the other party's claim. It doesn't work like that in South Africa. I don't think it works like that anyway, but definitely not. You have to make the allegation already in your summons. So we right at the start, you must make sure you've got all the allegations in your summons. Otherwise, when you get to trial and you want to make an allegation and it's not contained in your summons, the court's not going to allow it, and you might have to apply for amendment. And again, as I said, obviously that's got cost implications. So do your homework, see what you must make allegations of, and make those allegations. All right. So all legal requirements must be alleged. So again, if you have to comply with the National Credit Act, you must make those allegations, and you must specifically say that we've complied with this in this section of the National Credit Act. As I say, if you can get AMBLRs, that helps you make to tell you what allegations you must make to prove a certain thing. Also, you must have a physical address within 15 km from court. If we're not close to court, if we like I am in Somerset West, then you need to appoint a correspondent. Please get permission from your correspondent to use them, because I find a lot of people choose us because they know us, because we lecture, and then suddenly we get papers served on us and we have no idea where this comes from or who this matter is. And also you might have a clash because somebody might be suing your client and you don't know about it. They went to another attorney, but you have a clash because now you have to act against your client and you're not entitled to do that. Even they might not have been a client for a while. So please be courteous to your correspondents or your colleagues. Get permission that they can act as your correspondent wherever you need to issue summons. You would then put in the summons that you will accept service by email and fax. I don't know if any of you still know what a fax is. It's busy dying very quickly, but used to be big, when I started doing my articles, that was the thing. Now it's starting, I don't even think anybody has a fax machine anymore, but you can indicate how you want to accept any exchange of pleadings. For the summons, it must be signed by the attorney if the attorney drafts it, or if the plaintiff drafted it himself, the plaintiff can sign it. However, it's very important to note for a combined summons, you must have the attorney and advocate or attorney with right to appear in the High Court must sign. So you must have 2 signatures. Even if you're the attorney and you're signing in your capacity as the attorney and as an attorney with the right of appearance, you sign twice. I know it sounds stupid, but that's just how it is. So please make sure that you sign it as the attorney with the right of appearance, that you sign twice, or otherwise the advocate must sign and the attorney with the combined summons. There used to be quite a dispute if attorneys are allowed to sign summonses that are in another division, but in terms of the Legal Practice Act, Section 25, if you're admitted to appear as an attorney, then you practice throughout the country, and therefore you can sign a summons in Cape Town if you admitted as in the Western Cape, and you want to issue summons in Gauteng, you can sign the summons even though you're not admitted in Gauteng, because you are practicing throughout the country. So we don't have that problem anymore. To be admitted as an attorney with rights of appearance in the High Court, you must be admitted and then appear or have practiced for 3 years after being admitted. And you apply to the Registrar of the High Court to obtain a certificate. That certificate is supposed to then go on a list to the LPA or LPC. I'm not sure if they're doing it automatically. I know when it came in, we had to send them proof of our certificate so that they can start a list, so that the High Courts know who can appear in front of them. But I don't think it's really being kept up to date. So always have your certificate with you. I know the taxing master, they keep on asking me to appear it or reproduce it if I act on taxations, which I find to be very annoying. But be that as it may. So I know that's in your future and you're not doing it now, but keep that in mind if you are admitted as an attorney and then also to appear in the High Court, that you have a copy of your certificate with you. These requirements that I'm giving to you now is in terms of the rules, and you have to comply with this, otherwise it can be an irregular step, and we'll have a look at that just a little bit later. So how you describe the parties, obviously the sheriff must know where must serve the document, firstly, and secondly, the defendant must know who is suing him. So the name or initials and surname of the plaintiff and the defendant, the address of the residence or work, the occupation if known, gender. If you are suing in a representative capacity, you must state the capacity. So normally what you would say is nomino officio, so you have an NO after the name. And also the defendant, if you're suing them in a representative capacity, you must state that it's a representative capacity. If it's based on contract, then you must state in your papers, in your summons, whether it's oral or written, when, where, and by whom the contract was concluded. And if it's written, then obviously a copy must be attached. You will note that nowhere in those requirements is a requirement for the ID number. I do know that it, especially when the banks issue summons, they add the ID numbers. And I understand why, because obviously there's a couple of John Smiths around and you need to get judgment against the correct one. But please note that in my opinion, that's a contravention of the POPI Act, because you're giving too much information. So be aware of that. So I would suggest that you don't do the ID numbers, especially not on the front of the summons, which is very public and everybody can see. If you are issuing summons on behalf of a bondholder, could be a bank or person, you need to make the allegation. And if you're cancelling the bond and you want to sell the house, you need to make your allegation in your summons, warning the defendant or drawing his attention to Section 26(1) of the Constitution, which then explains to him that he has the right to access adequate housing, and if there's any eviction, that right might be infringed, and the defendant needs to bring reasons to court as why that right should not be breached. Now, this is decided in terms of Standard Bank versus Saunderson in the SCA, and Elsa Goodwana in the Constitutional Court, which confirmed it. You won't find it in the rules. There is such a rule in the Magistrates Court. It's part of the rules there, but in the High Court, they haven't changed it. So this is a requirement in terms of case law. So don't forget it when you do issue the summons in terms of the bondholder and you intend to cancel the bond and sell the house. As I said, in the summons, you then indicate whether you will accept service of all further notices by way of physical address, postal, email, or fax. That makes life much easier and takes away the money you have to pay to the correspondent. If the action is then defended, the defendant may then in his reply confirm that he'll accept service by way of email or fax, and then also say that this is his email or fax where it can be sent to. Just on a practical side, I would suggest that you use 2 different email addresses. And if it's 2 different service providers, it's better as well, because I really find sometimes my service provider lets me down and not all emails that are sent to me gets to me for whatever reason. And then if I have a different service provider and the email is sent to both of those addresses, then at least the other service provider might inform me. So just as a backup, always give a second email address and preferably from a different service provider, just for in case the one service provider might have a problem on that day. If your defendant refuses or fails to give the consent that they will accept service by way of fax or email, you can go to court to ask for that consent. I've never seen that. Normally people are happy to accept by way of email, because obviously it's it's easier for everybody and it makes it more convenient and cost effective. But just keep in mind that you are allowed to go and to court should the other party refuse to do so. Okay, practice note. Now, every single High Court division has got their own practice notes. And you will note that actually sometimes they enforce these practice notes much stricter than they do the rules. And the reason why there are practice notes is to make the life easier for the judge. Please remember that a large part of our job is to make the life easier for the judge or the presiding officer. We are presenting our client's case. And the best way to represent it obviously assists the client. You might have the best reason and best course of action in the world, but if your papers are horrible and typed wrong and doesn't comply with these requirements, the court's not even going to listen to you. You must remember, I don't know if you've ever been to motion court. In motion court 16 was 16. I think they've moved it, but in any event, if you go there, you'll see how many files the judge has to read, and that is only like half a day that he has to read it. And the same with opposed matters and actions. They don't have a lot of time to do. They're in court every single day. So for them to prepare on the papers, they only have the night before if they're lucky. And if those papers are not in order, then immediately you are on the back foot, because they will tell you, no, we're not happy here. And so part of your job, and unfortunately mostly it's the candidate attorney's job, is the index, pagination, that of it. I cannot explain to you how important it is. I know you hate it. I know it's horrible. I know it's boring, but it is vital. All right. You must remember again, as I said, the judge is reading these things the night before. If the font is too small, it's difficult to read. If the size of the paper is not correct, it's difficult to handle. So although these things seem tremendously pedantic and you're like, oh my word, do they not have time for anything else? It's there to assist them, to make their life easier because they read so much. And part of your job presenting your case to the best of your ability with regard to how things look. Because if the file is neat and tidy and paginated, the judge is already happy because he can refer to things, he can turn pages. I was in court one day, and the judge it was motion court, and it was divorces, and the lady represented herself, which I thought was very brave. And she got up and she stood in front of the judge, and she said, and he said to her, "Yellow paper. Your pleadings are on yellow paper." And she looked at him and she said, "But it's recycled paper." And he said, "Oh, okay. Let's carry on. So don't do yellow paper or any other color paper. It must be white, A4 size. All right. Printed in black ink. In the High Court, only on one side of the paper, double spacing. When you go to the appeal court, you will note that they request to be printed on both sides of the paper. So you need to just keep that in mind in the appeal court. But in the High Court, one side double spacing. Font not less than 12 points. All right. The margins on each side, 35 millimeters. Why? Because when you go on appeal, these matters have to be bound. And so you need to have enough space so that the writing is not cut off. If you ever read a piece of paper where like the last 2 or 3 letters of the word is cut off, you will know how irritating that is. And the judge is not going to be happy. So you need to leave enough space at the sides for you to bound. Now, I mean, when you're going to High Court for the first time, obviously you're not even thinking of appeal. You're not there yet. But this is why these things are being brought in. It makes you think ahead. I always say to my clients when they walk in and they present their problem to me, I'm at the Constitutional Court already. All right? We might start in the Magistrates Court, but I have to prepare my papers and I have to think ahead and say, all right, we might go to the Constitutional Court. So I have to raise my constitutional points now already. I have to do my margins now already. Because if I bind it in terms of the requirements of the Appeal Court and the Constitutional Court, they want 3.5 millimeters. And if my papers are not adhering to this, that means I have to redo them. So obviously, again, cost and time involved. So this is why it sounds stupid, but as I said, it has a point. You're looking towards the future. If your document is not A4 size, say for instance, like a marriage certificates, they're usually that small little size, then you put them on an A4 paper, and I usually just staple them, or you can just put print or whatever on and make sure that it sticks there and it doesn't flow all around. Again, so that it turns easier and they don't suddenly have a smaller piece of paper which they have to turn when everything else is A4. In the Western Cape, on the left-hand lower corner on the first page, you will have the name, telephone number, and email address of your attorney. And where the litigant acts in person, then that should also appear. Again, it makes life easier. So, say for instance, the judge says you need to quickly say to the registrar, quickly find this attorney, I need ABCD. Then she doesn't have to go rifling through all the papers and find a telephone number. It's right on the first page. It's easy to see. And sometimes, the first page gets separated from the rest of the documents. Then again, it's easy to see who to contact. I make it a standard. It's even on my magistrate's court pleadings, just so that I remember it. So you can make it standard, keep it there in the right left-hand corner on the first page, on all your documents. In your templates would be ready, and you don't have to keep on remembering to add it. And again, as we know, the registrar can refuse to accept that if you don't comply with these requirements, and then you have to go back all the way and redo your documents. For a combined summons, you also need to comply with Rule 18. So firstly, your particulars of claim must be divided in paragraphs. So one distinct averment is one paragraph. You sometimes get the summonses with these long paragraphs, and it just carries on and on and on. It makes it very difficult to plead on these papers. If you plead, remember you have to say we deny or admit the contents of this paragraph. If you got 600 different facts in a paragraph, it makes it very difficult to plead on it. So you do one fact, one paragraph.
Sorry, ma'am, can I ask you a question?
Sorry, yes, Yasmin?
I just want to know, if we're drafting the exams, do we need to take note of all these things with regards to the paragraph and the line spacing and the text as well?
Well, you're going to write, so you're not going to type, am I correct? So you're not really going to do a font size, you're not really going to do double spacing.
Sorry, the spacing, will they not ask us if it's like, not in order, or I'm just curious.
Would they not ask you to do what?
Would they not, if you don't have the spacing correctly when you are writing in the exams, would that be a problem?
No. I would suggest that you do paragraphs and you number them, because that helps with the marking.
Okay, thanks,
remember, you also, when you do exams, you're presenting, and you must think of the examiner. He's marking how many papers, 200, 300 papers. It gets difficult. So if you make it easy for him to read, then also it assists you. But you don't have to comply with all these regulations, because it's you're writing an exam. It's not a pleading as such, and you can't do the margins and the font because you're writing. So that is not important. But I would suggest that you try and keep paragraphs and numbers and not just everything in one.
Okay, thank you.
All right. Okay. All right. So when you do your pleading, as I said, one paragraph, one distinctive element, so that the other party can plead to it. And you're not doing it to make their life easier. Again, you're making the life for yourself easy, so you can see what the answer is to your averment, and the judge can see what the answer is to your averment. So again, it goes to presentation, goes to ease of reading. You're making the life easier for the presiding officer, so he can see, right, this averment is denied or accepted. Okay, when you're denying an allegation, go to the point of substance. Don't do so evasively. Okay. Again, as I said before, if you're relying on a contract, written or oral, you need to give that information. If you have a copy, it must be annexed. When you do matrimonial, you get more into the division and transfer. I'm not going to explain to you, but just remember that if you're claiming division, transfer, forfeiture, and a divorce, you must give details. You can't just say I'm claiming transfer. You can't just say I'm claiming forfeiture. You must set out the reasons why. If you're claiming damages, so usually with your RAF matters or your medical malpractice matters, there is a whole host of requirements. I'm not really going to go through them in detail, but you need to specify your extent of your injuries, separate the amounts into pain and suffering and disability. Again, to make it easy for pleading, to make it easy for court to understand exactly what you claim. It also helps you to say, all right, how am I going to prove this? Medical cost, all right, here's our invoices. Those are easy. Pain and suffering is not that easy, but we have our case law to substantiate that. So always when you draft, you must also think, how am I going to prove this? This also assists with the drafting. The High Court Note 33 of the Western Cape deals with your compliance of the NCA. So there's a specific practice note which says that if you're suing in terms of the NCA, you must allege compliance with Section 127, 129, and 131. So make sure you make those allegations in your summons. Otherwise, that can be raised as a defense as well. We've spoken briefly about the days with regard to the state, but interestingly enough, the High Court still has differentiation with regard to the DAs. So if your defendant is within the jurisdiction of the court, it's your 10 business days, so it's your court days. So that basically is 2 weeks. If your defendant is outside of the jurisdiction of the court, so say for instance, you are now suing because the whole cause of action arose within the jurisdiction of the court, but your defendant is staying in Durban or wherever, then he has 1 month if the address is more than 150 km from court, but 2 weeks if less. So in effect, if it's less than 150 Ks, then he also only has 10 days. Make sure that you indicate this in your summons, especially if your defendant is staying outside of the jurisdiction and is more than 150 Ks, that he knows he's got a month. If it's the state or province, as we said, 20 days. Dies non is from 16 December to 15 January. What does that mean? It means that if you issued summons and the summons was, say, for instance, served on the 15th of December, the defendant doesn't have to do his defense within 10 days, because you're not allowed to take judgment or do anything until the 15th of January. So he would normally only have to do the defense after the 15th. The question always arises, well, do you count the 10 days then from the 15th of January? I must be honest with you, I'm always cautious, and I would take the last day as being the 15th of January, just because I don't want to get into this fight. So do your defense, even though it's dies non, as soon as possible as a defendant, to protect your client. So don't take the chance and say, okay, well, let's only count 10 days from the 15th of January. Rather do it sooner than later. There is a new rule, 41A, which came into being on the 9th of March 2020. And in terms of this rule, whenever you do an action or an application, so even if you do a summons or your notice of motion, you need to attach Form 27 to your notice of application, and then also to your notice of defense. And this is to indicate if you will accept mediation or not. And if you say, I'm not accepting, I don't want to mediate, you need to give reasons. I must say to you that I've received quite a number of applications since the 9th of March, and none of them had this Form 27 attached. So I'm not 100% sure how strict the High Court is complying with this, but in terms of the rules, you must do it. Yes, Yasmin.
The High Court is strict about it, because I've been doing matters and they request for it, especially with RAF matters. So the Form 27 has to be attached to the notice of intention to defend, especially.
Okay, is that mostly for RAF matters?
So far that I've done, yes, ma'am, but it is a requirement from other colleagues that I've spoken to. The Form 27 is very much applicable.
Well, it's interesting to me that you're saying only in the notice of defense, because the rule specifically says in your action, so attached to your summons and application as well. But I think it's slowly starting to come in. It takes a while sometimes for these things to trickle through. All right, but I'm glad you're telling me at least it's it's starting to come in, and please remember this.
I've been doing it since March as well. I've been attaching the Form 27 since March to all the matters, majority of them, to the High Court.
Okay, all right. So my guys are not complying, so I can take it as a defense. I like it. All right.
Yeah.
Okay, so now I was carrying on and banging on about all the compliance of the rules. So you keep on, you're saying, Sonia, really, why? What does it matter if the font is 11 and not 12? What can I do? And the fact is, if you don't comply with the rules, it's deemed to be an irregular step in terms of Rule 30. And so now we come to what I spoke about earlier, what was the strategic planning. You now decide, all right, am I taking the step or not? It's not the job of the defendant to mop up after the plaintiff. So if the plaintiff has buggered up his summons, then why should the defendant tell him about it and give him an opportunity to fix? That's the one point. The other point, however, is also that the court might say to you, you know what, you had the opportunity to do an irregular step or exception, and you didn't do it, so I'm now not going to assist you. So it's all good and well to say, you know what, I'm not assisting the plaintiff to fix his papers, but once you get to trial, that might actually turn against you. So it's a fine line you need to decide, but this is now where you take the strategic step to say, okay, do I raise this? Because as the defendant, remember, you don't really have to do much. We call it the dead rat defense. You just lie there because the other guy wants the money and you don't want to pay the money for whatever reason. You might just not have the money, but that's, you know, or you don't want to pay him because you don't like him. But for whatever reason, but you don't have to do much. You just do something if you get kicked, and you must be kicked hard before you do something. So what we normally advise people to do is to say, okay, look at this. If there's mistakes in the summons, then raise it by way of the irregular step, because now you're causing the plaintiff to fix something. He's incurring extra costs. So remember what I said, the plaintiff has come to you as the attorney. This Mr. B or defendant costs, you owes him money, and it's a lot of money. It's R1 million. He's not getting paid. So plaintiff is not happy. He has to pay the attorney to issue the summons. Now the summons come back, now it gets defended, and now the defendant says, you know what, your summons is not right. This and this and this and this is wrong. You need to fix it. So the plaintiff is not going to be happy because now he has to pay extra to his attorney to fix the things. If he doesn't fix it, there's a possibility that the whole summons can be thrown out. All right. So we'll come back in detail how to do the irregular step and what the consequences are. But again, this is why I'm banging on about the requirements with regard to the rules and the practice notices, because you can have the problem that your summons can be dismissed. You're not even in court. You might have to then start over again. Again, plaintiff has to pay you, and obviously he's not going to be happy. All right. So finally, our summons is now issued. Once you've done your summons, you take it to court, gets issued, get a case number. At the moment, I think things are just getting left at the front, and then you have to come back in a couple of days or weeks and get your summons back. So it's a bit frustrating. But be that as it may, you then take it to the sheriff, who needs to serve the document. And he can only serve it from 7 o'clock in the morning till 7 o'clock at night. He's not allowed to do it on a Sunday, only warrants of arrest. And if you can't effect service, so say for instance, you are Sonia. Sometimes I leave the house at 6 o'clock to be in Cape Town, and then I'm only back at 10 o'clock at night after being in Cape Town the whole day. So they would not be able to serve a summons on me, and this is going on for weeks. They can go to court and they can say, you know what, Sonia's only there from 10 o'clock at night. Can we serve after 10, as an example? So you can ask court. And then, as I said, you indicate in your summons whether you will accept service by way of email or fax. And then, sorry, I just wanted to make sure, and hand in registration of post. All right. Okay. Can you read this?
It's very small, ma'am.
Very?
It's a blur and it's small from my side. I don't know about the others.
Okay, can you just have a look at that? This is an exam question, and there are 10 items that is wrong in the summons. And there are more than 10. And you would be able to pick up things that are written in large letters, and you don't really have to go into too much detail. You'll pick up quite a number of problems. So I want you to have a look at this and tell me what problems you can pick up with the summons with regard to all the rules and regulations we've just spoken about in the practice notices, so that you can see how quickly it is, easy it is to get 10 points in the exam.
It's very blur, ma'am.
Can you read? Can you read the
No,
top?
can't
Let me
read.
ask you. In the Supreme Court of South Africa, Western Cape High Court.
Yes,
can
we
you read
can
that?
read.
Sorry?
Yes.
Can you read that?
Yes.
We can read it.
Is it correct?
Yes, I can also.
Yes. No, it's incorrect.
It's incorrect. Why is it incorrect?
Because the defendant stays in Durban.
Okay, that's one reason. Was it you that spoke now, Chantal? I saw a hand. Or is there another reason why it's not right?
Didn't they cite the Court incorrectly. It says in the Supreme Court of South Africa, then it says Western Cape High Court. Isn't that incorrect?
Yeah, it's supposed to be the High Court of South
That's right.
Africa.
Yes. Okay. So the heading is not correct because it's not the Supreme Court of South Africa it's not right. Okay, so that's one point. Then somebody touched on the fact that the defendant stays in Durban, all right, KwaZulu-Natal. So you've got the wrong jurisdiction. Do you agree?
Yes.
Okay. Yes. So now it's John Jones, an adult male plumber living in KwaZulu-Natal, and then Jay Smith, a minor who resides in Pretoria. So Jay Smith, a minor, can he sue in his own capacity?
No, he doesn't have capacity.
No, he doesn't have capacity. He has no locus standi.
All right. So who needs to sue?
The guardian.
His guardian. All right. Just let's call it a line that was drawn with regard to case law. If the minor is under 7 years old, all right, then the guardian would sue in his name, in his capacity as guardian. So it would be, say, his mother, M. Smith, in her capacity as his guardian. If he's older than 7 years, then you would say J. Smith assisted by his guardian. I don't think it makes a difference. And if you do one when he's older than 7, or it doesn't matter. It's just the guideline of how it's done. All right. So he cannot sue because he's a minor, and he needs to be assisted. All right. Then we're saying, okay, there was a vehicle, and that vehicle was driven by the plaintiff. It was involved in a collision with a Mercedes vehicle with the registration number so-and-so, owned by the defendant. And the collision occurred in November 2017 in KwaZulu-Natal. Those averments, are they correct?
Isn't it incorrect because it refers to the defendant being the owner of the car and not the driver?
Yeah. The fact that he's the owner of the vehicle doesn't automatically make him liable. You need to sue the driver because the driver caused the accident and therefore he caused the damages. You can, if it was in his if he was working, so vicarious liability, then you make the allegation that he works for Jones, and therefore Jones is liable because of vicarious liability. But you would also add the driver, because maybe the owner then says, or the employer says, he wasn't in his scope and capacity as employment, and then he's liable in his personal capacity. So as the plaintiff, you need to cover your butt, if I can call it that, and sue both of them. For if that defense is raised, you need to think ahead as to what defenses can be raised, and especially if it's you're making the allegation it's in his work capacity, scope and work of his employment, then that can be raised as a defense, and then the employer falls away, but the driver is still liable. So the owner, you don't necessarily have to sue the owner because he didn't cause the damage. All right. Then in the next paragraph, we're claiming 450,000 Rand at 18.5 per annum, percentage per annum. Is that correct?
I think the interest rate is incorrect. The tempora.
Okay, which is what?
I'm not sure. I speak under correction. It could be 23.5. I'm not sure.
All right, we're going to come back to that. And then the date with regard to the interest. They say that's the 12th of November, which is the same date as the accident.
I honestly can't see the screen, ma'am. It's very blurry on my side.
I'm telling you now. What I'm telling you. I'm telling you The accident, it's alleged that the accident happened on the 12th of November, and they're asking interest from the 12th of November. I want to know if that is correct.
It's different years.
I think it's different, yeah.
Okay, there's different years. Why would that be?
Is it not 14 days after the payment? I'm not sure.
Okay. From when can you ask interest?
From the date you sent letter of demand.
Yes, letter of
Date of demand, all right, or your date of your summons. Or if it's a contract, sometimes yeah, but that would be your date of demand. So be careful about that. Make sure that if you do a demand, then you're entitled to obviously ask for interest from that date. If you don't do a demand, you're only going to be entitled from your interest from your date of summons. All right. Okay. Then if we go to the second page,
Sorry, is it the date of the
Yes.
summons? Yes, okay.
date of summons, yes. Okay. Then if you go to the second page at the top there, it says that you have 10 days in which to file your notice of defense. Would that be correct?
No.
Yes, it is correct. Oh, in my opinion, I think it's correct.
Okay, those that are saying it's not correct, why are you saying it's not correct?
Because they reside more than 150 kilometers from the court.
That's correct. So even though your jurisdiction is not correct, because it's outside of the jurisdiction of the court, and it's more than 150 Ks, you do your month. Okay. Obviously, the address of the court is also incorrect. Okay, have a look at the address of the attorney. Is that correct?
No.
Can't see, my screen is blur.
Sorry, just say again, it's what?
No, because the attorney's address should be within 15 kilometers of the court.
Correct.
Their address don't have to be within 15 kilometers. They just need to appoint an address of service within the 15 kilometers.
Yeah, so they haven't done a correspondent.
Yeah, but the
within
address that they
15
gave
days
is
of
not
the-
within 15 kilometers of the court.
Yeah. Okay. All right. Do you see? I just want to give you a feeling of the type of questions you can get in the exam, and you can see this is quite easy. You don't really have to write a lot, and you can just look and keep all those rules that I told you about, and keep that in mind. And it's easy, 10 points. Okay. So let's go to the interest rate, and you indicated that it's mora interest. Does anybody want to tell me how do you calculate that?
Is it not as per the prescribed amounts that the minister prescribes for that particular year? So, for example, you would go and find the percentage in November 2019 or whatever particular date that you would be looking at. So the current percentage is 7.75% that was just amended. But if your summons was served last year and that's the date that you're going for, I think it might be 10%.
Okay. All right. So you got the general gist. Let me explain it to you this way. All right. So before the 8th of January 2016, you used the Prescribed Rate of Interest Act. And in terms of that act, the minister would then from time to time prescribe the rate. So, for instance, from 1 October to 1993 to 31 July 2014, it was 15.5%. So, for nearly 20 years, it was 15.5%. At that stage, then the interest rates dropped quite a bit, and it was felt that it's unfair that the people that you take judgment for would pay so much more interest. And so, from 2016, they then changed the act. And what it changed to is that you take the repo amount plus 3.5%. So how do you know where we get the repo amount?
No, ma'am.
All right. So you should actually listen to the news. It's either today or somewhere in this week, 4 times a year. Well, actually, it's more now. The Reserve Bank announces what the repo rate is, and that is the rate that the banks can lend money to and from each other. So it's very low. And that changes, as I said, or it might stay the same. So you need to start listening to the news as to what the repo rate is. I think they are going to announce this today again. It's changing, and they thinking it's going down. So during COVID, it changed quite a lot because of trying to stimulate the economy. So you would note from these dates that it's changed. If you look at 1st of November this year, it's changed. All right. The repo rate is 3.5%. If you add 3.5 to it, you get 7%. So the top 2 rows is the Mora interest, and the bottom 2 rows is the repo rate. So whatever the repo rate is that they are announcing today, you would add 3.5% to. And then that amount, it doesn't kick in today. It kicks in on the first day of the second month after the change. So let's look, for instance, on the 23rd of July 2020, repo rate was changed, lower to 3.5%. Your Mora interest then changes from the 1st of September to 7%. Do you understand how that happens? And as you can see, I'm keeping a list of how things are changing, because you need to look when your cause of action arose. So, for instance, if we're going on demand in that summons we showed previously, and let's say they gave the demands on the 17th of November 2019. So 17 November 2019, if you look here, the repo rate, the Mora interest was 10%. From the 1st of September to the 29th of February, 10%. So your November demand falls in that time frame. So you are allowed then to charge or ask for 10% more interest. Once your judgment is granted, so say for instance you get judgment and it's 10%, it doesn't change. So you don't keep on changing your interest rate once judgment is given, then it stays the same. So if you got judgment in 2014 and they haven't paid the capital yet, you're entitled to 15.5% interest, even though we are now 7 years down the line and the interest rate is down to 7%. So you can see it's quite onerous. So keep that in mind. You're going to have to listen to what the repo rate is. As I said, it gets announced quite recently. I'm not seeing anything. I'm quickly looking at my notes. Not anything today. And then you would note then during COVID. So the repo rate changed on the 19th of March, on the 14th of April, on the 21st of May, on the 23rd of July, and it's going to change somewhere now in September again. And then you need to make a note of that and remember that in a month, the first of the second month, the first day of the second month, it's going to change. They do announce it in the government gazettes, but sometimes it only gets announced after it's changed. So you need to keep abreast of this so that you know what your interest rate is if you issue your summons. All right. Do you have any questions on this? All right. Okay, we're going to skip that video. Okay, so remember we spoke about when you issue summons, you must make sure that you join all the parties. So everybody that's got a vested interest in this matter must be part of it. and that you mention them, that summons get served on them. Obviously, sometimes things happen that you don't know that there's another party, especially with accidents. If you're suing somebody and you're saying, right, you caused the accident, that person might say, no, there was a chain accident, and the person behind me knocked into me, and as a result, I knocked into you. So I'm not the cause of the damages. The person behind me is the cause of the damages. And as plaintiff, you might not be aware of it because you only took the client only took the details of the guy that knocked into him. So the question then arises: how do you add for the people to, if I could call it the party, to the action? And we have 3 different ways of dealing with it. First one is intervention, joinder, and third-party notices. So this happens after your summons have been served, and you then realize maybe they pleaded, and now you realize, oh wait, there's other people that needs to join the party. So let's just have a look. Firstly, there's joinder. This is in terms of Rule 10 of your High Court rules. As I said, all parties who have direct and substantial interest in the relief that the court may grant must be joined. So if you have more than one plaintiff against one defendant, you can have different causes of action. So say, for instance, you are suing A because of defamation, but B also have a claim against A, but that is contractual, then it can be done in the same summons. You just need to obviously differentiate against what the different claims are, but you can have one summons with more than one plaintiff against one defendant. Obviously, there's a cost implication that you save costs. Instead of 2 summonses, we only have 1 summons. We can have more than one defendant. This, however, there must be the same question of law or fact. And when you join them, it can be jointly liable, the two or 3 or 4 defendants, however many you have, jointly and separately, or in the alternative. So there's various options as to who you can claim from what, but again, the same summons can go out against more than one defendant as long as you have the same question of law or fact. If you joined as the plaintiff and you're unsuccessful, then you may have to pay the other plaintiffs as well as the defendant's costs. So it's not a party you can invite everybody to. You must make sure that they need to be there. If the defendant is joined, then against the defendant, the successful defendant, the plaintiff may have to pay cost. The unsuccessful defendant may have to pay cost, or there can be a pro rata division of the cost, and one plaintiff pays, or one defendant pays 60% and the other defendant pays 40%, or however many defendants there are, the court could decide what percentage of the cost they must pay. And once you've gone through all the PT of joining everybody, somewhere along the line, they can also bring and ask for the separation of the trials if there's a good enough reason. So we can have lots of fun. If you don't join when you should have, then it's called a non-joinder, and you raise it by way of a plea. So you would get to the plea and you say, I'm not the one that's liable. This is the one that's liable. You should have, added him as well. If you join somebody that should not have been joined, it's called a misjoinder, and you raise it by way of a point in limine. It's just different ways of raising it and dealing with it in trial once you should get there. And then you can apply to join somebody, as we said, with regard to Rule 10. Rule 10A says that if you are challenging the law by the executive authority, then you need to join them. So if you are saying that the Tax Administration Act is unconstitutional, you must join the executive authority that deals with that act, which is the Minister of Finance. So they must be joined. If you're challenging a validity of a rule, so say one of the rules of the High Court, you're saying that is invalid because it's against the Constitution, it's unconstitutional, you must give notice to the Rules Board, and join them so that they become part and they can then explain to court why they've done the rules and what's the ratio of the rules. So these are joinders that you have to do in these specific instances. Examples of joinder, it would be joint ownership. So say more than one party owns a car, both of them needs to then, if you're suing them, be joined, or if they're plaintiffs, both of them must sue. And as we discussed already with regard to the driver of the vehicle, you would add him as well, even if you feel that he might not, be able to pay. It doesn't matter. He's the one that caused the damages. He must be added. And depending if you are joining the employer or the owner as well. All right. The second option you have is intervention. So any person entitled to join as a plaintiff or be joined as a defendant may apply to intervene. This is usually used in insolvency. So the creditor would say, you know what, you are not placing all the facts before court with regard to the insolvency, and I would like to intervene to bring more facts to the court attention so that they can make an informed decision if this person must be placed under sequestration or the company under liquidation. This is in terms of Rule 12. So you would normally just stand up. A lot of times people would stand up on the day that the matter is heard in the unopposed role and said, we would like to intervene. And then the matter would be postponed to give them an opportunity to file their papers. So basically you would say, I, as a party, would now like to join this because I feel I can assist the court and bring more information to court. Then we have what we call third-party procedure. This is in terms of Rule 13, and you're looking at Form 7. And the third party would then be liable for contribution or has indemnified the party issuing the notice. So substantially the same question or issue has arisen. In your notice, you must then set out your nature of your claim, the grounds of claim, the issue to be determined, and the relief sought. And then all your rules regarding pleadings will apply, which is what we've dealt with, the double spacing and those kinds of things. That would apply to a third party. All the copies of the pleadings up to date must be served on the third party. It's served by the sheriff. And then the notice without copies is delivered to all other parties because obviously they have the pleadings already. So they don't have to get it again. It's just a third party that's new. He needs to get it. But they need to know that a third party is coming in, so they need to get the notice. If your pleadings has already been closed, then the court must consent to the delivery of a third party notice. The third party must deliver a notice of intention to defend if he intends to contest the matter. It's very important to note that your third party notice is not a summons. The result of that is that you cannot take default judgment against the third party. If the third party does not defend the matter, then you do not have to give him any further notices or documents, but you can then get judgment to him at the end. So you can't take default. You can only get judgment when the matter goes to trial. Your third party may accept or plead or otherwise contest the matter, just like any other defendant. Can also put in a counterclaim, but only against the party that issued the notice. So even if it's, you're not allowed to do it against any other party. And again, as I said, after we had all this fun and games of doing a third party notice, we can apply to separate the trials on any issue if the court will allow it. So the third party notice is very important to note the dispute is between the party issuing the notice and the third party. There's no dispute between the third party and any other party to the litigation. The third party is only co-defendant, and you can only get an order for apportionment of fault in the form of a declaratory order. You're not entitled to claim judgment in money. If you do issues, provide complete the provisions of Section 2 of the Apportionment of Damages Act, then you can apply for judgment. That usually deals with motor vehicle accidents. So if you do put your third party in terms of that act, you can get a judgment. So remember what we said with regard to High Court. High Court is entitled to do declarator, Magistrates Court not. And then sub-rule 28A10 of the Magistrates Court Act actually brought in the fact that you can get judgment against defendant, all right, in the Magistrates Court, when you do the third party. However, that is beyond the authorization or what the Magistrate Court Act had. So this rule has been declared ultra vires or ultra vires. So in actual fact, third party procedure in the Magistrates Court is a bit of a deduct because you can't get a declarator and you cannot execute. So it's a problem, and I think the legislator must still sort it out. But until that time, you've got a problem. Just going back to here, in the High Court, you get a declarator. So say, for instance, the court finds that the third party is liable for 20%. If that third party doesn't pay the 20%, to be able to enforce it, you need to issue summons again. So against the third party, you're going to say the reason for my cause of action is a court order which says you must pay 20%. Obviously, that doesn't happen a lot because it's got a cost implication, because then the third party has to pay more cost. So normally they would then pay on the declarator. But unfortunately, if they don't and you have to enforce it, you need to issue summons against the third party. Your defendant may then, instead of the third party procedure, institute separate proceedings and then apply for a consolidation of the proceedings. So you, as I said to you, there's lots of ways to skin a cat. Keeping this in mind if you need to add parties. All right. Are you confused? Okay. Let's just go through this again. So the list, that's the dispute, is between A and B. A, right, wants to claim a relief against C. He didn't issue the summons against C because he didn't know about him or he forgot or whatever. Then he must bring an application to join C. All right. So that A, as the plaintiff, is dominus litis. So he can decide who he wants to sue. So if B raises a defense to C, I'm not liable, C is liable, A can take the chance and say, no, I believe you're liable, I'm only going to go against you. Should the court then say, no, you know what, B was right, he's not liable, it's C, and your matter is past 3 years, A is going to have a problem because he's not going to be able to sue C because of prescription. So always rather cover your butt and join C, just if the court decides, okay, no, C is liable, or if the court might see B is 40% and C 60%. If B wants to claim a contribution or indemnity from C, B may do so, all right, by doing a third-party notice to C. Remember, B is not dominus litis. He's not the guy that decided where I'm going to sue and who I'm suing. So if he wants to bring somebody in, he can only do it by way of the third party. If C wants to join, all right, he wants to join the party, says, no, this is nice, I want to come in, I'm here, then he does an application to intervene. So if C is outside, A and B is not interested in C, but C feels that he can contribute, he can then apply to intervene. Okay. Clear as mud. Okay. Look at this question and then tell me what the solution is.
A and B are divorcing. Is the plaintiff who is the defendant part of American community out of community? As well, I feel that assets of trust must be included for calculation.
Yeah, trust assets aren't included.
Sorry, say again.
I said trust assets are not included.
Not at when they issued summons.
Yeah, as far as I understand, even with the divorce proceedings, they're still not included because it's
No, there
specifically
have been court cases. Your trust is not a arm's length trust. If the party used it just as an alter ego, you are entitled to claim the trust assets. So, but you obviously have to then bring the trust in. So how do you do that?
Have no idea.
You have to prove that the trust is has been used as an alter ego.
Sorry,
so then must be the wife bring and a notice for the third party to join the trust as a third party, because the trust is essentially a separate entity.
Exactly. Yes. So if sorry, just hang on, maybe now. Yeah. So if B is bringing in the trust because she wants to claim against the trust, she needs to do a third party notice. Okay.
Just sorry, can I just interrupt you? So if she's not a beneficiary to the trust at all,
no, it doesn't matter. No, she probably would not be a beneficiary of the trust because the husband would use the trust where he and maybe the children are beneficiaries. And he would use the trust as a way to hide his assets from the wife so that she doesn't have a claim against it. Look, obviously she still has a mountain to climb with regard to proof, because if the trust is legit, it's a separate legal entity and she's not allowed to claim against it.
Is
but
this the matter with
if she can prove that it's his alter ego, he's using it just to hide assets from her, then she's entitled to go behind the veil of the corporate entity and claim the assets.
Okay, is this only applicable? Is this only applicable when they are married with accrual? If it's without the accrual, not
married. Married in community of property or accrual. Obviously, if they're out of community of property, it's not entitled to it anyway, unless you can show other things. But as a rule, in community of property and with accrual, if he hides his assets so that it doesn't fall within the joint estate, and she can prove that it's not a real trust, he just uses it to keep the assets from her, she's entitled to
understand.
All right. The other option that she has is if the reconvention is against the plaintiff and another person. So in this instance, he would say, all right, I'm claiming 50% and then from the assets, and she would say, no, I have a claim in reconvention of 50% plus 50% of the trust. Then, and the trust is not part of it, then she can put in a claim against them in reconvention in terms of Rule 24(2). If there's no claim against the plaintiff, then you have to follow the third party procedure. So you can see there's lots of options in the rules for you to claim from other parties. Just make sure that you comply with all the requirements, and be careful not to just add everybody, because they obviously can, if as we said, if you joined somebody that you shouldn't have joined, it's misjoinder, and they can get a cost order against you. Okay. So we've got our summons is out, it's been served, our 10 days or however many days we had, if it's the state or the out of the jurisdiction, that has gone. Then you can apply for default judgment. All right. So you can also do that if they fail to deliver the plea, or if they fail to deliver the declaration, or either if the plaintiff or defendant fail to appear at the hearing. So there's various times you can ask for default judgment. In the High Court, the registrar grants judgment where the debt is liquidated. In terms of your Practice 33, again, you need to do an affidavit to confirm that you have complied with your NCA requirements. And you're looking at Form A and B in terms of your practice notes. Remember, when you do when your debt is not liquidated, you have to set the matter down to be heard in the court, in open court. So you would set it down for notice of motion. In Cape Town, we're setting down, I don't know how they're doing it during COVID, but it used to be around about 20 matters, which they set down for default judgment. And then also further matters, if you want to declare your bond, and get your house executable, because that has to be overseen by court as well, and you would set that down in motion court as well if the matter is not defended. If you've taken default judgment either by the registrar or in court, the defendant can apply to set the judgment aside within 20 days of the knowledge and good cause shown, or otherwise, in terms of 31(5)(d), if he's dissatisfied, then it can be set down and reconsidered by court. That doesn't mean he's saying I'm not owing, he just say maybe the amount's not right or something like that. So there are various options for the defendant to come back and say I'm not happy with default judgment. You can do rescission of judgment in terms of the common law and in terms of those rules, and then in terms of Rule 31 as well. And it's changed. You used to not be able to ask for rescission in the High Court if you've paid, like you can do in the Magistrates Court, but that has changed now from the 11th of March last year. So now you can rescind with consent of the plaintiff, or if they don't want to give consent and you can prove that you paid in full, you can also apply for your rescission of judgment. So it's the same as in the Magistrates Court now. Remember, if you do a simple summons and the matter is defended, you must do a declaration. What a declaration is basically particulars of claim. So if you do a simple summons, please be aware that you must do your declaration. If you don't, then they are allowed to do, the defendant now is allowed to do a notice of bar, and they could set the matter down and ask for absolution, or they might even give evidence in front of court to say, I don't owe the money, and the court could give judgment against the plaintiff and dismiss the matter with cost. So be careful as the plaintiff's attorney. When you do a simple summons, it's defended. Please remember to do your declaration. Don't think the matter will, nothing will happen. They might go to court and get judgment against the plaintiff. If you didn't plead, you have your notice of bar in terms of Rule 26. You give 5 days to say that if you don't plead within the next 5 days, I'm going to take judgment. Again, if the 5 days is done, you're not allowed to come and do the plea unless you've got consent from the plaintiff to do your plea late. Very careful, all right, because you can't do it after the 5 days. You have to do it before the 5 days. And if they don't give consent, you need to bring an application to court to grant you longer time to do the plea. Again, we've got a dies non. So if you have a notice of bar served on you on the 15th of December, there's a dies non till the 15th of January, where they cannot take judgment against you. So you can only do your plea afterwards. Again, I'm just saying to you, be careful, be cautious, and rather do your plea as soon as possible. If it's really difficult for you to plea, get instructions from your client, make sure he understands, and just do a bare denial plea. Just deny everything if you're struggling to get instructions. But then you must warn your client that there's a possibility that they could bring an application, for exception because it's a bare denial, which has a cost implication. But at least that gives you a little bit of time to then fix up your plea if you really cannot plea within the prescribed time. But get full instructions on that and explain to your client the consequences so that they can't turn around and say, well, you've now incurred extra cost because you just did a bare denial plea. All right. For the notice of defense, again, address within 15 Ks. If you do it after your DAs has lapsed, but judgment has not been taken yet, it must be accepted. So your defendant's attorney can't say to you, while you're outside of the 10 days now, I'm not accepting it. If they haven't taken judgment yet, it must be accepted. As we said, there's a DA's non from the 16th to December to 15th January. So if they serve the summons just before that or in that time, you don't have to do the defense immediately. Must give your full business and residential address. And then, as I said, you agree to the service by way of fax or email. It's the same requirements as in the summons. Okay, so we're now going into a defendant action once your notice of defense have been served. So this is just a short overview of the process, and we're going to go into detail with all of them, but just so that you have an overview. So firstly, obviously, we have our summons, and then we have our different days that we have for notice of defense. If it's a simple summons, then within 15 days after receiving the notice of defense, the declaration must be served. And then either within 20 days, if it's a combined summons, 20 days with within the notice of defense, or 20 days after the declaration, the defendant must do its plea, counterclaim, or its exception. Summary judgment has been changed. You used to be able to ask for summary judgment after the notice of defense, but the rule has been changed, and you can now only ask for summary judgment after 15 days after your plea. In my view, that really makes the summary judgment nothing more than an exception if you look at the requirements, and it's taken away really the aim of the summary judgment, which was to stop the matter if they defend the matter just because to gain some time. So summary judgment has sort of died a death, unfortunately. It used to be very useful method that you had to get to the defense more quickly, but the courts never liked it very much, so it's changed, and now you're only going to be able to ask for summary judgment after your plea. You can then, after you've pleaded, do a replication or plea. If you put in a counterclaim, then the defendant must plea on the counterclaim. You can do a replication and reconvention. Once you get here, you're in trouble, because that means you didn't, draft your plea correctly or your counterclaim. So make sure that you draft them. They must comply with all the other regulations and rules as summons, so that the party knows exactly what they must plead to. They know exactly what the claim against them is. We then get to close of pleadings, very important part of the process, because you can only do certain things after the close of pleadings. So after the close of pleadings, we can ask for further particulars. Remember, that's not a fishing expedition. You must just ask very pertinent questions. Then we do discovery. Now, those of you that have done discovery, the affidavit can tell me it's boring, it's horrible, and I know it is, but this is a very important part of trial, because this is now where really you see what the other side have, how they're going to prove their claim, and this is normally how you understand for the first time how you're going to prove your claim. And this is a lot of times where we realize and say, oops, we won't be able to prove that or that. So now is a good time to settle. So discovery is a very important part of your process. Then after the discovery, you would do your notice of trial, and you would have a pre-trial conference in terms of Rule 37. Very important, very effective, in my opinion, because a lot of matters of mine have just disappeared after the Rule 37. I never heard from again. So it's a good place again to settle, you know, and the judges sit down and say, right, this is, you know, this is what you acknowledge, this is what you deny, what you must prove, have you discovered, that type of thing. And then at the end of the day, should we not be able to settle and sort it out, the matter goes to trial. All right, so let's look at our declaration. As you said, only if you haven't done if you've done a simple summons, then you do a declaration, and it's like I said, particulars of claim must comply with all the rules that we've done for pleadings, you know, your numbering, your spacing, that type of thing. So it's absolutely a pleading. It looks like your particulars of claim. So it's not Greek, might be a little bit Latin, but not Greek. So make sure that you comply with that if you do a simple summons. Okay. I'm just referring to your notes. Make a note of that. Once you get your notes, that you are looking at maybe drafting a declaration, just to assist you to know how to draft it. Again, as I said, the questions, the answers will be provided to you, so you'll be able to check your answer to see if you're correct. But do yourself a favor, and I know we don't like doing it, but draft. It will assist you in the exams, in practice as well, so that at least you know you get into the rhythm of what words to use and how to do it. Because unfortunately, we have to learn. It's not something you're born with. Okay. So now we come to an irregular step. We've been speaking about it for some time, and I've explained it to you. And I've said to you, you know, what happens if you do something wrong. So irregular step is something which contravenes the rules of court. And you mustn't do anything after that. So if you have the summons and you note they haven't complied with the rules and you want to do an irregular step, all you can do is your notice of defense. All right? Because the minute you plead, you basically accepted that summons and you cannot do an irregular step. So you need to be very diligent and read your summons. When your client brings the summons, read it. Even that small print, you know, the one at the back, which is part of the template. Sometimes people use the wrong template. And then you can do an irregular step against that. So don't do anything else other than your notice of defense. If you plead, you can do an irregular, this is now, all right, for pleadings. So if you plead and there's an irregular step with regard to plead, don't do anything further. Don't do your notice of discovery or whatever. You first have to do your irregular step and raise it before you do next step. Because the minute you do the next step, you acknowledge it. It's sometimes easier to define something as to what it's not as what it is. So say, for instance, your non-compliance with other legislation. And remember earlier on, we spoke about the Institution of Legal Proceedings Against Certain Organs of State Act, which is your notice that you need to send. And the question then arises, if you haven't sent this notice, is it an irregular step? And what the court has said, no, it's not really an irregular step. It's really something you raise by way of a special plea. So if you didn't send your notice, as we said, and you issued your summons, and the state then defends it, they would raise as a special plea that you didn't do your notice as you are required. If your address is not within the 20 Ks, or your address is 20, so remember we said 15 Ks, if it's like 20 Ks, or in the instance we had that summons where it was in Pretoria or Johannesburg, where the court was in KwaZulu-Natal, then it's an irregular step. If your summons does not comply with Form 2 or 2B, then you can bring in a irregular step. If your parties is not set out, details are not correct. So, for instance, you didn't make the allegation that they are an adult male, or something like that. If you're suing because of session and you didn't make the allegations with regard to session, that's also an irregular step. Or the summons doesn't contain consent to judgment. So all these small things. Again, as I say, the probabilities that your summons will be dismissed because you're not within the 20 Ks are very slim. But you can bring that if you want to say, all right, I want to now go up to the plaintiff and say, you're wrong, and I want to say to you, you need to redo this and get a leverage to do settlement. It's something you can do. All right. As I said, court's probably not going to throw it out because it's not within the 20 days, and especially these days with the email and fax service, it's not so important anymore. But be careful and comply with it, because the other party is entitled to raise an irregular point, and it's always a bit of an embarrassment to explain that to the client and say, well, sorry, my summons was wrong. So, we try and avoid that. Okay, so what's the process? Firstly, you check either the summons or the plea or the counterclaim to see, does it comply with all the rules? And then you take no further step. If it's a summons, you can do the notice of defense, but that's it. Then you notify the party to rectify the regular step. So you give them an option. It's not, you just say to them, look, this and this and this and this is wrong with your summons. You have 10 days to fix it. If they then don't fix it, all right, then after the 10 days, you draft your application, you give them notice, and you serve it and you deliver it, and you place it on roll, and you have to collate, number, secure, deliver, index. So like a full-on application. All right. If it gets defended, then obviously you go to the defendant role, you get a date there with Zane, and you place the matter on roll, and you do what you're supposed to do. Very important when you go to the High Court is always have draft orders, so that you can just hand it up and say to court, this is the draft order. You must adhere to your practice notes, and your heads must comply with that. And then you appear and you request your order. So normally what you would order is say, you would actually say, all right, you give them another 10 days to fix up whatever their problem is. So, say for instance, they didn't describe the plaintiff correctly or the defendant correctly in terms of the rules. They didn't say he was an adult male or whatever. And then you go to court, they don't oppose it. You get your order, and the order would normally say, right, within 10 days, the plaintiff must fix it. If the plaintiff then doesn't fix it, then you go back to court and you say, all right, they didn't comply with the court rule. And now you actually, your application is that they didn't comply with the court rule. It's not so much that they didn't describe the defendant correctly. It is now they didn't comply with the court rule. And as a result of that, your summons then gets dismissed with cost. So then the action is gone. You've won as the defendant without going to court really to debate the merits of the matter. Plus you've got costs. So can you see that from the plaintiff's view? Obviously, this is not good because he's lost the case. He has to pay, and he has to pay the defendant's cost, and he hasn't even gone to court yet. And for the defendant, it's basically the end of the matter, because the summons is dismissed. He doesn't have to defend it anymore, and he's got his cost. So you can see the dire consequences of these stupid rules, which we thought at the beginning, what it can have if you don't comply with it. So let's just have a look, because there's an exception as well. All right, so you can either do an irregular step or an exception. And the difference between the two is that with exceptions, your pleading is inherently defective. So the allegations that they made. So for instance, in that summons that we did earlier, the fact that they didn't make the allegation that it was the driver that caused the accident, all right? That makes it vague and embarrassing, and or it discloses a cause of action or a defense. You can have both, all right? So you don't have to just have one. If it's vague, all right, you must send a notice to remove the complaint within 10 days of receipt of the pleadings. And if there's a defense, then obviously it's going to be opposed. I'm just looking at this now. I do think actually that the act has changed, and you must give notice even if it doesn't disclose a defense. I normally do that in any event. All right. So the active change, you now have to give notice if it's vague and embarrassing or if it doesn't disclose a defense. So give notice. All right. So you would give the notice. And then the irregular step, as we set out, that is when you don't comply with the rules. You give your 10 days notice to remove the problem. If the applicant doesn't, if they don't sort it out, you bring an application to remove the problem. And if that is not removed, you're entitled to then get judgment. The exception is raised against the pleading as a whole, and the purpose is to bring the matter to an end. You also can get a notice to strike out, and that is if certain allegations, and this is more to do with applications, if there are scandalous, vexatious, or irrelevant allegations in the affidavit, you can bring an application to strike out. You must, however, show prejudice. You must give notice of this application, and then again for them to fix it. If they don't fix it, you bring your application. So you can see there's various ways to attack the pleadings if they don't comply with the rules and if they don't comply with the law. And that would be the end of the matter. You would get rid of the matter before we go to court. So again, as plaintiff or defendant, you decide if you want to bring these applications. But again, especially if you can raise an exception, if it's vague or embarrassing or doesn't disclose a defense or cause of action, if you leave it, the court might say to you, you know what, you had the opportunity by way of exception to do it, you didn't, so I'm not going to help you. So be careful to say, you know what, let me leave it till the end and only raise it at trial, because the court might not assist you. All right. I think what we'll do now at this stage is we'll break for lunch. Half an hour, that enough? Anybody still there?
Yes.
Everybody still awake?
Yes, ma'am. Yes.
We're here. All right. I'm glad to hear. It feels like I'm talking in a void here. All right. Half an hour. Yes, Marinas. You raised the hand. Does that mean yes?
I don't think they realize that they're raising their hands.
Okay. So let's have a break for half an hour, and then I'll see you at 12:30. All right. Thank you.
Okay.
Comics, yeah, say that your microphone is muted. Then how can you hear yourself? Don't lie.
Okay. Hope you had a good lunch. We're now going to go further into the process of litigation and how to get to where trial. But along the way, there are various things that must happen. One, and two, there are various interlocutory applications you can bring. And again, it plays into our discussion with regard to strategic planning and how you deal with matters, because each of these interlocutory applications obviously has a cost implication, it has a delay action. So either if you're the defendant and you want to delay the matter, you can use this, but beware of the cost implication. Or if you want to, stop the plaintiff and say, right, that you're doing something wrong, and because of that, I'm bringing this type of application. So we've got all these options. First one we have is an application to compel. So if you don't comply with your time limits, so for instance, the request for further particulars, you fail to deliver that, then you can bring an application to compel, give them 10 days notice. If they don't comply, then you apply for court to the appropriate order. All these things are there to curtail the matter. You can dismiss it, without going to trial, or create some more costs, irritation, if you want to call it that, for the other party. So all along the way, we have these applications, considerations, which we then, as the party, must make and decide if we're going to use it. Is it to our benefit to use it? Is it not to our benefit to use it? It depends solely on the circumstances. I can't tell you, you must do this every time. It depends on what your instructions are, what you want to achieve. But just be aware that you have these options and that you can use it, again, to advantage, but you must obviously always remember the disadvantages as well. So application for compel is one. Again, that's an interlocutory application. Notice of bar, we've discussed. Again, if you haven't pleaded and you get your notice of bar, if you can't do it within the 5 days, you need to